Welcome, everybody, to this webinar organized by the EUIPO and 4IP Council about how IP helps to secure your business investment. My name is Axel Frazzini. I'm the Managing Director of 4IP Council, and I will be your host today. Moving to slide, there is something wrong here. Okay, you should be able to see the slide, the presentation slide, right? Okay, good. So 4IP Council is a not-for-profit research organization focused on the link between IP and innovation to identify the most relevant topics and produce empirical research. We work closely with a wide variety of academics, experts, IP organizations, and stakeholders. Everything that we do is freely available on the 4IP website. On our website, you can find a wide range of free materials. And here you have a selection. You have studies, guidelines, summaries of relevant research papers, summaries of court cases and recordings of our webinars. Moreover, we produce easy to digest, specially tailored for non-IP experts, SMEs, and startups especially. This is free of charge as usual. Some examples are interactive graphics and interviews to inspire startups and SMEs. With this, we aim to assist innovative startups and SMEs to learn how to use IP to grow their businesses. As you know, more and more things are increasingly connected, thanks to the Internet of Things. To achieve this, standardized technologies are needed, often protected by patents. This is why we have created a case law area with summaries of court cases regarding standard essential patents. This section is now also available in Chinese and in Japanese. But without further delay, please allow me to introduce our great speakers. Suzanne Hogan, Dr. Andreas Olmes, and Marco Bozzola. Suzanne Hogan has worked at the EUIPO, so the European Union Intellectual Property Office, for over 20 years. She's a communication specialist, part of the EUIPO Ideas Powered for Business network team, now dedicated to helping the EU SME Fund reach you. Dr. Andreas Olmes, principal and authorized signatory, has a PhD in physics from Leibniz Universität Hannover and invests in hardware-related startups at HTGF in the industrial tech team. Andreas has led numerous financing rounds and has already supported 9 successful exits, including the IPO of Mister Spex in July 2021. Okay, one of HTGF's biggest success. And Marco Bozzola is an inventor, a product engineer, a full-stack programmer based in Italy. He is the owner of a startup called Relio Labs. His flagship product, Relio, is used all around the world by cinematographers and scientific researchers. A final remark for the audience, for all of you kindly attending this webinar today, please do not hesitate to use the Q&A tool to submit your live questions during the presentation and the discussion. You can find it at the lower part of the screen. Okay, do not mix it up with the chat. This is the Q&A tool. And while you can raise your questions during the presentation, we will take them during the Q&A. And the questions will be addressed after Suzanne's presentation. So Suzanne, the floor is yours. You should be able to unmute yourself with the button.
Okay, thank you. I'm so sorry for that. Thank you, Axel, and sorry for that small delay there. Thank you again for IP Council for inviting us here today. I'm here to represent the EU IPO and to tell you about our special Ideas Powered for Business program, which is a program especially developed for you as small and medium enterprises, and it's implemented thanks to the help of national IP offices and also of stakeholders such as For IP Council today, who really help us reach out to you, okay? It aims to cover 2 areas of interest for you to help with your businesses, basically guidance on intellectual property world and money, that's its financial help. Now, before I jump in to explain how this program can help you, I will quickly number crunch on what the EUIPO is and show you some practical examples of what IP is and its benefits. In a few minutes, you'll have a much better understanding of IP, I promise. I will then open your eyes to how the Ideas Powered for Business program could really help you attain IP and really help your businesses to fly. So, the IPO, as Axel just said, is the European Union Intellectual Property Office. IP is what we're all about. We offer IP protection to businesses and innovators across the EU and beyond. We are based in Alicante. We're an established organization. We've been there since 1994. And our core business is the registration of EU trademarks and designs. A little bit more number crunching here. We're approximately 1,600 employees working directly and indirectly at the office. And a number that I love a lot is this one. We process applications in 23 official languages because languages should never be a barrier. And some of our latest figures are that we now registered around 200,000 EU trademarks and up to 110,000 community designs. Now, in times of crisis, protecting your rights is more important than ever, and this has really been reflected in our figures. In fact, just on the 18th of March, we received hit the button here, our 2.5 millionth EU trademark application. So as you can see, our main business is intellectual property, IP, and our main focus is helping you with that, with IP. A little bit more number crunching here. We have, so IP, intellectual property, SME, small and medium enterprises. This refers to you yourselves, okay? It's startups. So you really are the backbone of EU economy, and right now the world needs you more than ever. A recent study done between the EUIPO and the European Patent Office through these figures, apparently only 9% of European SMEs actually use intellectual property rights. However, those that do report a 68 higher revenue per employee over time on average. Now, this is just some of the figures that are in this report, but it's quite astounding. If intellectual property is so useful, why do so few people use it? And the answer is simple. It's lack of knowledge. What exactly is IP? In a nutshell, IP is this: ways to protect your business creations and innovations. So what I would like you to do now is to pick up your phone, have a look at it. It has a brand or a logo, iPhone or Samsung, okay? That is protected with trademarks. Now, if you have a look at your phone, its overall appearance, its look and feel, this is protected with designs, another type of intellectual property right. And its technology, its touch screens, its batteries are protected with patents. So I've spoken about 3 different types of intellectual property rights, which are the 3 we're going to talk about today: trademarks, designs, and patents. Another easy to do example is pick up a pair of your glasses. If you wear glasses, have a look at them. On the side, you'll see that the glasses have a brand. This is protected with the trademark. The overall look and feel of the glasses, the design, are protected with designs. And the actual technology to help me, in this case, to help me see better, perhaps I should put them on, is protected with patents, okay? So now you have a basic overview of some types of intellectual property rights. So what are the benefits of protecting these, of protecting your business creations and innovations? The first one that jumps to our mind, click. First one that jumps to our mind is that it prevents others from copying it. But it's not only that, it's the only form of legal protection you have to protect your creations and innovations. You can legally prosecute others that copy you and vice versa. If someone accuses you of some infringements of copying them, you have some legal weapons you can defend yourself or negotiate with. Now, if you've prevented third parties from copying your idea, you get something that's called market exclusivity or competitive advantage. Now, this is especially, I think, of interest to small and medium or startups companies, because IP rights really prove to be powerful weapons when you can compete with larger companies. Intellectual property is also a fantastic tool to use to market your products. Okay, this R symbol here, for example, really informs the public that the brand owner believes in their product and doesn't want competitors to ride on its reputation. Likewise, if you see patent pending or patented statements in marketing, these really give a message on how just innovative a product is. Now, these messages really appeal to both customers and, topic of the day, investors alike. Another huge benefit of intellectual property is that it can open up. It gives you freedom, yeah, to export and market abroad. It's a great way. It's a good basis to quickly scale your businesses. Yeah, for example, if you want to go on the global e-commerce marketplaces, Amazon gives priority to sellers that have intellectual property rights. And another benefit, which is the topic of today, it actually gives you more access to finance, because intellectual properties, protected creations and innovations really attract investors and partners more than those that are not protected. And I'm sure we're going to hear more about that today. So you now have, that was really quick, you now have some basic IP knowledge, and you have basic understanding of why IP could really be a good business asset for you. But now, where to start? And this is where the Ideas Powered for Business comes in, okay? It covers two areas of interest to you, which is guidance and support, and then financial help. So what sort of guidance do we offer? Well, we offer, to start off with, we really recommend and offer this free personalized consultation service. What is this? Well, basically, what we've done, this is a free service for you. If you're at a loss right at the beginning, this is a free service. We've created a pool of volunteer professional IP experts, and we match you with one to give you basic personalized intellectual property advice. It's just basic advice. It could be as basic as what type of IP right could be right for me. Yeah. So there's no need to be at a loss. The current figures that I got out just yesterday are that we currently have 250 providers, that is volunteer professional IP experts, and almost 1,300 SMEs have successfully used this service. So it's a great practical starting point, a guidance to start off with. Okay, so great, you're thinking to yourself, wonderful, perhaps IP is right for me. But what about the money? That's where the other part of the Ideas Powered for Business program jumps in. Together with the Commission, we have created a 47 million fund. 47 millions. And each one of you here, as startups or small and medium businesses, could potentially save up to 2,250 euros each. Now, I want you to know, we want you to go away with a really clear idea of what you can apply for with this fund. I'm going to try to make it simple as possible. The fund works with a system of vouchers. We have voucher 1 and voucher 2. I will explain the four-step process afterwards. So what does voucher 1 include? So you would apply for voucher 1 or 2 or both. Okay. Now voucher 1 includes a service called IP scans. Now this is basically the next level up to the free legal consultations that I just mentioned before. This is organized by many EU national IP offices, not all of them, but many of them. And what they do is they designate, they have a pool of IP experts and they designate them to you, and you meet up with them and you collaboratively together, you examine your business model, your products or services, your growth plans, and to determine and set up a whole and a complete IP strategy. Now, after these consultations, you receive a full report with this IP strategy, and they propose a set of best practices and recommendations on how to manage, protect, and further develop your IP rights in the future. Now, this may cost a lot. In some countries, it may cost up to 1,500 euros, but you get reimbursed 90% of these fees, okay? A reimbursement of 90%. First of all, you pay, and then you get reimbursed. Something else covered in this voucher 1 are the types of IP rights that the EUIPO covers, which is trademarks and designs. Here, we also offer help at national, regional, EU, and international level. And I'll give you one example. For example, if you wanted to register a basic EU trademark, an EUTM, this would offer you coverage in all EU countries, okay? Your trademark will be protected in all EU countries. The basic fee is 850 euros, but with this reimbursement that you have, it would cost you just over 200 euros. Instead of 850, 212.5 to be precise. And if you wished to register a community design, therefore you would have protection in all EU countries for your design, this would normally cost you 300 euros, but with the reimbursement, it would cost you but 75 euros. Now, voucher 2 deals with patents, because although the EUIPO deals with trademarks and design, this fund is done in collaboration with the Commission and also national IP offices who deal with patents. And therefore, we also reimburse 50% of patent fees at national level. Okay, so interesting, fascinating. How do I go about it? The process is really, really simple. First of all, you apply for the grant. What does that mean? You apply for voucher 1 or 2 or both. You wait not too long to receive the grant award and the vouchers, and only then, please wait, do you request and pay for the IP activities that you wish to use. Once you have requested and paid for them, you can directly ask to get reimbursed. Okay. So if you would like any more information, please use the question and answers or go to our EUIPO website and our social media. I have to say, we have just recently launched an Ideas Powered for Business Twitter and LinkedIn accounts. And please remember, up to 2,250 euros could be waiting for you. And now could be the great time to invest in IP and really help your businesses fly. With further ado, thank you very much, Axel.
Thank you, Suzanne.
Pleasure.
This was a brilliant presentation. I mean, the message is very clear. Now you know what potentially IP can do. You know who you have to talk to. You know how you get some funding. Let's move to the next step and have an investor and an entrepreneur joining the discussion. And, you know, now that we have seen the SME Fund, we have learned about the EU IPO and what it brings. Let's start with one question for Andreas. Many startups have raised many questions in preparation of this webinar. And I have to say that the first question is, okay, my startup, you know, most of the time that's three persons in a room. My startup is an engineering office. Do I need patents?
When you start up as an engineering office, what does that mean? We see them sometimes too as a venture capitalist, and we have to be honest. We can't finance them because an engineering office is very typically selling the time of the engineers. So there's no scaling with a product. they're selling the hours of their engineers. And that's the reason why we can't finance engineering startups, pure engineering startups. And that's the reason why it makes no sense, at least from my perspective, to have any patents, because your know-how is just what's in your head, and what you can offer your customers with your work directly. So at least from my perspective, I don't think there is a need for IP protection.
Okay, but now my startup produces very simple but completely new hardware products. So I'm innovating, creating hardware. That's simple. And do I need patents?
I have a very interesting company in my portfolio too. This is a Fitlock company over there. We sold them very successful. This company produced magnetic closures. You may know them from bags for children, or from holder for water bottles at your bike. And this is it's a very brilliant idea. The two components fit to each other just by magnetic force, and then they hold these two things hold to each other mechanically. And if you want to get those both in space again, you have to twist it, and then you can disconnect it. And this idea is very, very easy but brilliant. So the competition is very keen to copy it, and it's very easy to copy it. So in this very special case with very easy hardware, you're definitely in the need of having a patent. Especially this company, the time we sold that company a few years ago, had more than 50 patent families. And it was extraordinary, but it was necessary because there was so many competition trying to copy it, and they patented everything. And yes, the answer is yes. You're definitely in the need of having patents.
Okay, so something simple, easy to copy, and then they needed to file patent applications to protect their invention. But now, if my startup is a deep tech company, we create very complex technology and very hard to copy. Do I need filing patents or not?
It's a bit more difficult, this question. If the product is the opposite of easy hardware, so it's difficult hardware, you may could think of not need a patent. But and that's true in the very beginning. If you are not successful, but at the time you become successful with your company, this deep tech hardware is usually disruptive, and that leads to your competition trying to copy it, like with the easy hardware. So in that case, you need patents too. And you may think of a different reason for patents in this case, and in the case before too. It's the situation where these companies will be integrated in a different company, or will be bought by a larger company. All these companies look for a proof that you own your hardware, and that's being done by patents too. So yeah, the answer is yes.
Okay, that's very
in this case.
Now, if we switch gear with Marco, because you gave examples of do I need or do I don't need a patent, what best case scenario. But Marco, as an entrepreneur, first, what's your innovation? Let's just to understand what it is about, and then how it connects with intellectual property.
I'm the owner of a very small startup. Indeed, I am the only component of my startup. So you have in front of you the whole company. And what do? I engineer scientific lighting products that are used in cinema and in scientific research and institutes all around the world. We lit very important art projects, very important and very ancient drawings by Italian artists. And we collaborate with the universities in a light engineering project, custom projects. And this is basically what I do. What I do has needs two kinds of protection. I develop proprietary technology, so I need to protect it. And also, of course, my brand is a very important asset of my company, for my company, because we build trust by working with high grade and very important institutes. So the brand that sponsors some artistical and cultural initiatives with this kind of technology grows and becomes important and recognizable. So I think that the two things that for me are very important protecting are my brand and my technology.
Okay, so trademark, checked. Fine.
Yes.
Technology, patents, check.
Yes.
No design for the product?
The design, well, it happens that the past year I won the Design Europa Awards with one of my designs, but I won't call myself a designer. My design is the consequence of streamlining my technology and, of course, the packaging. The case where you place your technology into is important as well, because it's something that it's the thing that your users, be them professionals or common users, touch and interact with. It's not the technology, but it's the tangible interface. So design is not just by itself an asset, but can become an asset because it makes your technology recognizable to the eye. So of course, I also have designs registered for my products. But well, I'd say design, if you are a design company, of course, you are going to protect your design. If you are a technological company, design can become something to protect when you feel like you did a very great job and the design itself becomes something valuable. And well, regarding, I want to add one thing that is a question that my friends ask me a lot. When do I have to think about intellectual property protection? Do I have to do everything before starting a company or before launching a product or before even engineering and thinking of a product? And my advice is to look at this question from behind, from another point of view, is how thinking about protecting my assets first can help me better shape my idea so that it can be valuable, it can be unique, and it can approach a known problem from a different point of view. So I think that the value of IP protection is not just as having an asset or a weapon to how to say to avoid being copied. It's something that can make you grow from inside yourself and help you better shape your idea in a way that is not a copycat of something already existing, but it's a different approach to a known problem.
May I add something to the design issue? I made that experience with my job before HTGF, where I was have been in charge of sales in a small company, and we introduced a US-based optical measurement tool in the German-speaking markets. And after 2 years, there was an additional option where the eye surgeon could add another feature to that optical device. And this feature was very useful, but you just needed a small lens. That was everything you needed, and you just put it in front of that optical machine. But the value of that additional feature was really high. So the US company decided to put this lens in a very well designed box of polished by piano varnish, and it looked really good and versatile. And then the price for that lens went from, let's say, $200 to $5,000, and it was accepted because the customers saw these really fine box made out of wood with a special treatment outside, and you can open it, and it was really nice, and this design was protected too, and showed the value of that lens, not the value of the lens itself, but the value of the lens for that additional application. And that's an additional point with this design IP.
That's a very good point. Something simple, if well put in, promoted using design, can definitely have a greater value. I have a question for Suzanne, because that's something we have received in preparation of this webinar, and we have just received it as well in the Q&A. Remember, you can use the Q&A tool. But Suzanne, the vouchers 1 and 2, and the grants that are available part of the SME Fund, are they available for all the countries, even if there are non-EU countries like the UK that is not part of the EU anymore?
That actually personally hurt then, Axel. As a British, this is a fund for EU countries, so the business would have to be based in the EU to be able to have access to the fund.
So it must be part of one of the 27 countries.
Yes.
And then you can submit through the process you have indicated.
Correct.
So if my startup is based in the UK, can I just open a subsidiary in one of the 27 countries and then apply?
As long as that subsidiary has a valid VAT to accreditate it as such, then yes, you could.
That's brilliant, actually. So that's not really a big barrier. That's a barrier. But if I want to leverage the SME Fund, I just need to create a company with a VAT number in one of the 27 countries. Perfect. So this is now clarified. Then we received another question in the Q&A, which is related to something that is easy to protect or easy to copy. And maybe that could be for Andreas. So you said, if it is easy to copy, protect it. But if it is a patent, for example, you divulge information through the patent application. So a patent application that is filed will become public 18 months after the filing date. So it means that the content of the patent application will be known 18 months after the filing. It means that anyone may be able to copy my invention using the content of my patent. So can you clarify, is that true? Is that an issue? Do you keep it secret like a trade secret? How you choose?
Yeah, this was a typical behavior, especially with German-based founders with scientific background in the let's say 15, 20 years ago. They don't want to say anything to anybody, but this has changed. In the meantime, founders realized that that from one aspect, it's not very easy to copy something. They overestimate that it is easy to copy, but that's not true. It's very difficult to copy something. So there is no, from that perspective, there is no need to be very careful with such information. Of course, I'm not talking about the deep source of these things, the very typical issues, but just the basic ideas. I'm just talking about basic ideas. On the other side, founders or founder teams in the meantime understood that time is the issue. If you're not fast, you will fail. So I made the best experiences with founder teams telling everybody everything, but of course not the deep secrets of the manufacturing or something like that, but the ideas behind, because then they get a very interesting feedback from all these people they are talking to about their idea, and they can improve their ideas much faster than first developing everything and then going to market. So the answer is, in the end, is it's not an issue. At least it shouldn't be an issue. But I know that there are some founder teams still behaving like that. But that makes no sense, to be very honest.
Oh, very good. Another question for Marco. Marco, you are not a lawyer. You are not an IP patent attorney, but you went through the IP rights. You checked the design, the trademark, and the patents. How did you learn as an entrepreneur about intellectual property?
Okay, first advice, always make use of professionals. Do not do everything by yourself, but being able to speak the same language of your consultants is of paramount importance. Either because not all consultants are good, so you have to be able to discern which of them are superstars and which are not. How to become knowledgeable so that you can speak the same language of your consultants. It's very easy indeed, and the first source of information, I think I'd say it's the EUIPO website, because it's very well made. I have been a full stack web programmer for the first years of my professional career, and the EUIPO website is very, very well made, both from a technical standpoint and from an information content standpoint. So my primer was that website, and once I went through it all, I started talking with the consultants, and it was very easy to find one that was very knowledgeable. Another advantage of being knowledgeable is that you can expedite and speed up the consultancy process. So, as Andreas told, the time to market and also the time to register the IP is very important, is critical. So if you are very fast and you communicate well and efficiently with your consultants, things will go smoothly and very fast. So first source of information, my advice, go through all the EUIPO website, because it covers most topics. Then, at least in Italy, we have some websites that regarding patents, so technical patents are very well made, and they tell you almost everything about the process, and the process is easy as well, even for national registrations. And I've also found that the technical team of the EUIPO website is very kind, and you can ask them a lot of questions. I had positive experiences even before getting to know all of you by writing to the email support, and I got very prompt and very helpful replies. The second advice is to talk with friends or with acquaintances that have or had experiences about IP litigation, because most of the times you learn the most when you are inside, when you look at an issue, an IP issue, from the inside. So taking advice from someone, you will be surprised to learn that not every IP litigation becomes a war. Most of the times it's just a matter of conflict of interests. So of course, when you protect something you took a lot of time to develop, you try to cover everything, also the potential use cases that you won't ever use or make use of. So it's all a matter of human interaction. So you have to find a way to talk with the help of consultants, of course, with the other part, and then find a common point of view where both of you get to defend your own property without going into an actual litigation. So this is, I think, a very important advice, because I had a lot of issues initially when registering my trademarks and everything, and almost everything got resolved without an actual full-blown litigation. And the last advice is to read online cases of people that had issues, positive and negative experiences, because you have to think ahead. So before starting to fully develop your idea, you have to know what area you are going into. This is very important, both in terms of economic involvement and time and stress, because it's stressful if you don't know how to deal with it. It's not if you know how.
May I add something?
Yes.
Yeah, me too.
Okay, do you start?
As you like.
No, I go ahead. Go ahead, Suzanne.
Okay, now just to say that we hadn't paid Marco for that marketing there of our website. Thank you. But thank you. So I would say, yes, I would definitely recommend to read the information there. But I would just like a very quick reminder that we do offer these legal free consultations that didn't exist when Marco first started up. And the added value one, the IP scan, which we do give money back at we reimburse at 90%. So if you can't afford proper legal representation, you do have these two options available for you in most countries. Okay, I just wanted to add that in again for the people listening in. Thank you.
And I would like to add some experiences I made with my own company 20 years ago. These patents can become very expensive, even in the very early phase. There's a lot of writing and things to do, and I totally agree with Axel. You can't do it by your own. You have to have a patent attorney. That's a must. But you can you can reduce the amount of money you have to pay, so that and I'm talking about costs of 5,000 to 10,000 euros by two ways. The first is just try to draw the diagrams you need by yourself. This costs a lot of time for the patent attorneys if they do it by themselves. So I had a very good patent attorney. He told me, just do it by yourself. You can save a lot of money, and then try to make a first patent research by yourself, because you know all the detailed technical words you have to look for, and that's a very good base for a patent attorney to set on top. So you can do it both before. Of course, the very first step is to get the vouchers from the EU IPO. Then you do the work before, as I just mentioned, drawings and patent and the research. And then the third thing, maybe it's very typical for Germany. Here we have that pre-patent thing called Gebrauchsmuster. I don't know the English expression for that, but it's a way to describe your idea you want to have the patent for, and it can be done very, very quick, within a week. And then you have that Gebrauchsmuster, and then you have 1 year of time, 12 months, I think, where you can convert this Gebrauchsmuster into a patent. Maybe it's a very German typical thing, but that's another way to save some time and some costs in the very beginning.
That's very good. I would like to link actually Marco and Suzanne one thing. So Marco, I understand that when you have filed your patent application and you have filed design and and trademark, there was no SME Fund at that time, so you could not benefit from it. But if you maybe Suzanne, the question is how often or how many times can you benefit from the SME Fund?
Okay, so I think there was actually 2 questions there then, because you spoke about things that Marco might have already registered.
Yes, so he cannot benefit from the fund anymore, but
No.
he could still file for new design, new trademark, new patents, and then he could benefit from the fund.
Yes.
And if he benefited from the fund before, can he benefit from it the second time?
Okay, I get your question. Well, you can apply, I mentioned the vouchers, so there's vouchers 1 and 2. So you can apply for these vouchers once a year, and then you have up to 6 months to start using them. And then you can continue to use them between 6 and 12 months. You've got all of the information is now under our frequent asked question page. So you can apply for the vouchers once a year, and then you have up to 6 months to start using them. And then you can continue to use them over a period of 6 to 12 months, depending if it's voucher 1 or 2.
So a startup could do it like we are in March 2022, could benefit, register for the venture 1 and 2 now, use them before the end of the year, and in 2023, again, apply to use venture 1, venture 2.
Correct.
So Marco could benefit from the SME Fund for the version 2 of the Relio lamp.
Good to know.
That's very good. And you said that the company with the VAT number should apply. Should the CEO of the company or anyone of the startup could apply? It has to be somebody specifically or just a representative of the company?
Is this question for me, Axel?
Yes.
Yes. Who can apply for it? Well, the person can apply themselves, the business directly, or as Andreas was saying, they can have their IP representative apply for it. But when they get the refund, will actually go directly to the SME, to the person, not to the lawyer.
Okay. So there is no way to benefit from the SME Fund for something that I have registered 6 months ago, and it really has to be done before I start filing.
Yes, you have to apply for it before you register. Yes, because you have to comply with certain conditions which are indicated in our website as well. Basically, you have to prove that you are actually an SME.
Okay, that's very good. I have another question for Andreas and Marco. So the comment I received from a few SMEs and startups actually is regarding NDAs. As soon as you start talking about intellectual property rights, you are talking about NDAs. And between the startups with very little experience in IP and the venture capitalist funding many startups, there is also a question of trust. So how should I deal, if I am a startup, with the venture capitalists who are telling me, no, I don't want to sign your non-disclosure agreement. And if you want to talk to me, we can, but no NDAs. And Marco, how actually you have dealt with this situation? Both of you may have a different perspective. Please. Who wants to start?
I'd start first because mine is the simplest situation. When I initially started developing my ideas, I wasn't even a startup. I was an employee, a full-time employee. So I worked nightly on my ideas. And then it came a time when I had to tell my friends and my colleagues about my idea. And then subsequently also to companies, to other companies. And the issue and the topic of trust is very important. As Andreas told, it's very important to speak and tell your idea to as many people as possible, because you need feedback. You have to differentiate between telling your idea and the solution to a problem that you have identified, and the underlying technology that you are developing. So my advice is do not think much to an NDA initially when you are telling your friends and people you trust, and if you are able to isolate the problem and the solution and the underlying technology. Then if you are start working a lot on the technology itself, then an NDA could be useful, especially when you are talking with other companies, not to venture capitalists. And I think that Andreas will address the issue from a VC point of view. From my point of view, I started talking with the companies even before talking to VCs, because you start talking to VCs when you have something of value, or something whose value is measurable. Otherwise, it's very difficult to start talking, because you don't have any value to place on the table. And when you talk with companies, especially if you talk with big companies, they treat you horribly. I got asked many times to sign their NDA when I went to visit them to present my own technology, and this is absurd. So my advice is, don't fall into this trap, and ask these companies to start talking at a very high level, so no information being exchanged between the parties on proprietary technology, but just on the idea and on the expectations that you both have from each other. Then this can be useful to start jotting down an NDA which is very narrow and very centered, very focused on your technology, so that you won't have to ask them to sign a very broad NDA, and they will know what they can tell you and can't tell you if it generates a conflict of interest. So the trust, of course, has to be built. And the way to build the trust is to start talking at a way higher level than you maybe could want to, and use these high-level talks to help shape an NDA so that it's very narrow, so that the big company won't see it as a threat to their technology and won't ask you to sign their NDA. Never sign an NDA of a big company, otherwise you won't be able to develop anything. That's my advice.
I totally agree to Marco. Thanks for these open words. Yes, an NDA, a non-disclosure agreement between a startup and us as an institutional investor is a topic which we very seldom do. We don't sign these NDAs. We are allowed to sign these NDAs, but we do it just in very single cases. What's the reason for that? You should know that we as High-Tech Gründerfonds, we invest in 40 companies a year, 40 a year. So we have already invested in 650 companies, and these are just the companies we invested in. There are a lot more companies we have had looked at before, some thousands, and we cannot afford the time to sign these NDAs and the negotiations connected to these NDAs. That's one reason. And second reason is much more important. If we would copy the idea of a startup, even one single startup, we would never been able to do an investment anymore afterwards. So it's an issue of reputation. We cannot do that. Otherwise, we would be out of the market directly. Third point is, even let's imagine we would try to copy. A single investment manager would try to copy. It's the same with IP protection. I just mentioned before. It's so difficult to copy something. It's so difficult. The founder team will be much faster than me as an investor or investment manager trying to copy it. So it makes no sense to do that. And finally, it's additionally a legal issue. Let's imagine we would have signed several thousand NDAs already. It would be so easy for somebody of the founders to just to say, hey, Andreas has seen this company and this company, and he transferred information. And how can I prove that I haven't done that? So it makes no sense to do NDAs. There's one special point where an NDA will make sense, and that's with very special and detailed technical issues in a product. For example, that Lufos company you can see here, they developed an optical sensor for the measurement of distances, and in very rough surroundings. So I asked them, how do you do that? They measured centimeters with nanometer precision. And they told me in the very beginning, without NDA, oh, there's an interferometer inside the tip of the sensor of that size, some few millimeters, an interferometer. And then I told them, okay, I got it. Because then I understood the information is being created in the very tip of the sensor, and everything afterwards can be disturbed because there's no interference anymore. And then I told them, please don't tell me how do you prepare this interferometer in the tip, because I don't want to know it. I don't need to know it. And that was the reason why we never signed an NDA with them. I still don't know how they created this interferometer. In the meantime, one of the managers is a colleague of mine at HTGF. So it's a trust issue.
That's very, very good. Now that's time to conclude, and I would like to thank you very much, Suzanne, Andreas, and Marco, for sharing your experience. That's great knowledge, and I'm sure that will be useful for many startups, future entrepreneurs, SMEs, and to leverage intellectual property rights. Later today, you will receive an email inviting you to complete a 1-minute survey for future topics that you may want us to cover in the future webinars. So please send us your feedback. And as explained before, a recording of this presentation will be made available on the 4IP Council website tomorrow. Don't forget to register for the upcoming webinar, Artificial Intelligence and Copyright in the Creative Industries, that will be presented by Dr. Hailey Bosher. That will be on April the 20th. So don't forget to subscribe to the newsletter, subscribe to the EUIPO website, learn, nurture your knowledge about intellectual property, and subscribe to the 4IP website to learn about the future events and webinars. Thank you very much to all of you for participating, and I'm looking forward to talking to you at the next webinar. Thank you.
Thank you and your team.
Thank you.
Thanks.
Thank you.